Hello, my true crime lovelies. Sugar Bear says hi. He says that's your warning. Can you give me a one in the chat if you can hear me? I'm trying it from my phone today. I see there are a few people. How are you guys doing? Oh my God, you guys. The emotions, they were dropping them like it's hot. Thank you, Patsy. They were dropping them like it was hot, hot, hot today. You guys know there's a hearing tomorrow. I did also set up a stream. He's determined for my hand not to be up over here by his legs. I did set up a stream for tomorrow in the evening. Like I said before, I cannot have my own live for the hearing, but I'll be in somebody's live and I'll let you guys know. How's everybody doing this evening? Everybody have a good Wednesday. I was going to say Monday. It was my first day working, but yeah. I hope you all are well. Okay, without further ado, we're going to go through the motions. A lot of you guys sent me notes on this, and I appreciate you. She really wants this phone. What is up with the phone? What did she say? What's her line? Tell me and we'll both know. Okay, let me make that a little bit bigger for you guys. All right. Let me make sure you guys can see that. Okay. All right, let us, oh my God. My son is trying to expose me over here. Wait, let us get into it. Motion for return of property, or in the alternative, motion for independent exam by defense. So first and foremost, this title, it's giving a little bit of deception. We need a lawyer, but I don't believe they normally just give back a phone in the middle. I mean, you haven't even gone to trial, right? In an active investigation. I don't believe they do that. They can, as it was explained before, with the CSI people there, let someone on her team investigate it, but just to give her like unfettered access to go off and test it, I don't see it. But I know Sarah has asked for it. So again, I think this is Owens doing his client management. She's asked for it. So he's putting it in here. And then he also adds in the alternative, motion for independent exam by defense, which I think is what is going to happen. And all of the appropriate people will be there so we don't lose chain of custody. Because imagine if every defendant just got to run off with their evidence and do willy-nilly what they wanted. You know what I mean? So I feel like he put that in there for Sarah's benefit. Comes now, the defendant, Sarah Boone, by and through counsel, James C. Owens, pursuant to the Florida Rules of Criminal Procedure, and files the instant motion, stating in support thereof the following. The defendant, Sarah Boone, is charged in the above styled and numbered case in a one-count information with second-degree murder, which is punishable by up to life. So there's one. Yeah, there it is, up to life. The above styled and numbered case is currently set for jury selection on October 7th, 2024, before the Honorable Michael Kranick. I'm going to take myself out of the window because I don't want to have an R-rated stream here with whatever Sugar Bear's got going on. Okay. Ms. Boone was arrested on February 25th, 2020, after giving a statement to law enforcement. At that time, she purportedly consented for her cell phone to be searched, and it was seized. It was purportedly video evidence from Ms. Boone's cell phone that led to the filing of the instant charges, which we know is not accurate, right? Because we went over this in our discovery. I can't remember when we did it, but we went over it. They took her phone on the 24th, the day that she called, because a lot of you guys had pointed out later, oh, she couldn't have called his daughter back because they had her phone that evening. So it was the 24th. And they saw the videos that afternoon on site. She had already given her written consent. So we looked at those documents and her verbal consent. And so as soon as they found the video, they stopped in doing whatever they were doing to the phone, examining evidence on the phone, and they called for a search warrant. they didn't actually get the search warrant until the 25th. They got it like moments before her coming into the police station. Oh my God. And so this is not exactly true. So that's how they were able, they already had the videos to show her at the end of the interrogation. And in addition, we all heard her say a million times, like, hey, look at my phone, there's this, there's that. So she definitely wasn't trying to stop them from looking at her phone. So since February 25th, the defendant has been continuously in custody in the Orange County Jail without bond, and neither she nor her attorneys have had an opportunity to see and review her cell phone or to have it analyzed by an independent person or the defense team. I also don't know that that is true because Mauricio Padilla put in a request for a forensic analysis of her phone and a download. It was approved, and I don't know if it ever happened. Like, they don't come back and say that. We would find out at trial, right? There is not like a motion of completion or whatever. But he definitely requested it back in 2020. And I'm a little like, I don't know, what are the three attorneys doing? I feel like they should have this information down already. Do you know? Because he in no way references that prior request and or payment. So I don't know what's going on. Counsel on behalf of Ms. Boone have timely filed a notice of intent to use battered spouse. Much of the evidence in support of Ms. Boone's defense, including but not necessarily limited to battered spouse, is contained on her cell phone, including documentation to support this defense. The information contained on her cell phone includes, but is not limited to, text and photographs. Additionally, and perhaps as essential to her defense, is other potential evidence, such as witnesses, names, and contact information. So they have said multiple times that they have given her those files. Now, I know there was one, we talked about that earlier, where they had asked for the investigator, the forensic investigator, to go into the jail with his laptop because they needed this special program, right? Cellbrite requires a special app in order to look at certain documents. And also she would need, for the iPhone photos, something that was able to read a HEIC file. And it's, sometimes you can read it on a regular, like, PC, and sometimes you can't. So I remember that. But they do have the evidence. Now that Owens is on the case, if he can't figure out how to read, get the, something for him to get the correct format. Oh, yeah. That's on him. The Office of the State Attorney and their agents have had this evidence, i.e. said cell phone, in their exclusive possession for their exclusive use and examination analysis since February 25th, 2020, for 4.5 years. Presumably, the state's attorney's office, with their vast resources, financial, technological, investigator, etc., has had sufficient time to review and analyze all data from said phone and to transfer and preserve all needed putative evidence without the necessity of maintaining physical possession of the cell phone. Yeah. Now, if that's not snark, I don't know what is. They've had sufficient time in 4.5 years. Like, okay. The defendant respectfully moves for the court for an order directing the immediate release of Ms. Boone's personal cell phone to her attorney or a member of the defense team acting on her behalf. And then here goes the implications if he doesn't. Should they not grant the release? Should Kranick not grant the release of the cell phone to defense counsel? Counsel would move in the alternative to examine said cell phone, or to have a defense expert examine the phone to retrieve the much needed evidence to support her defense. Do you guys think Sarah is helping write this? Because I feel like much needed is so much like a Sarah-ism. Much needed, equally situated, whatever she says, to sit equally. Anyway, let me know what you guys think. Without this evidence, Ms. Boone will be deprived of her rights under Florida law as well as federal constitutional mandates. Under the Florida rules of criminal procedure, the prosecutor shall disclose to the defendant and permit the defendant to inspect, copy, test, and photograph any tangible objects that were obtained from the defendant. So I feel like this rule he's stretching it a bit because the phone is tangible, yes. The data on it is not, right? So I feel like that rule applies specifically, like if she hit him with a brick, she could inspect the brick. Well, the defense could inspect the brick. They could take it, copy it, test it, etc. But what kind of testing would she be doing on the phone? I feel like it might be applicable, but it feels a little like a reach. Should the defendant counsel and their representatives not be allowed to obtain Ms. Boone's cell phone, or at the minimum to obtain favorable evidence, not only will procedural state rules be violated, the result will become a violation under Brady v. Maryland and progeny. So if they're not allowed to find favorable evidence, how is that? I don't know how that's the responsibility of the court. Like, what exactly is he asking for? Not allowed to obtain the cell phone. He's implying, I believe, that they're hiding favorable evidence. And that's why he's bringing up the Brady part, right? I'm going to say objection assumes facts not in evidence. You only have it on Ms. Boone's word that there's favorable evidence because you're stating you haven't seen what's on the phone. So what are you guys? I want to see what you guys are saying over here. Can you imagine Sarah interviewing potential jury? Oh no, that's why I'm so glad she has counsel. Oh yeah, futuristically olive oil. That's another Sarah-ism. Like, oh my God. And they filed all of these like the night before, right? Because the hearing is tomorrow at 1:30. It's less than, well, I didn't see it until maybe 4:00. Maybe it was delayed on my computer, but it's less than 24 hours prior to the hearing. So he's got them, and maybe that's part of his strategy. He's got them, how do they say it? Is it flat-footed or caught you on your back leg or whatever? He's like keeping them on their toes. Did anyone pick up the attitude in her voice when she responded to the OCDC attorney? Oh, yeah. What's over and beyond? Yeah, she was trying to hold it together and let it slip when beyond hit. You know what I mean? Like, she was definitely not, yeah. And then nobody answered. It was a dead silence. It was hilarious. And then finally he said, Judge, I don't know if I'm a witness in this case. Is that directed toward me? You okay over there, little one? Oh my God, there he is. So it is, I really think it's like Sarah in those boxes. She wants that phone in her hand. And Mr. Owens is like, okay, we're going to give it a shot. But I mean, I just don't see them just handing it over and like to Mr. Owens and saying, okay, see you in a week with that phone back. Do you know what I mean? And it seems like that's what he's asking for. Like, just give us the phone and our expert will look at it. But I believe all of the other people have to be there as well, so you don't break the chain of custody, right? They have to have eyes on it because they're not even allowed to turn it on unless it's in that one room where it's not going to connect to Wi-Fi or internet. He is filing all of these motions because Sarah wants him to. I hope Kranich strikes the motion for BWS. I hope so too. Yeah, I just think these are, which again, if that's his version of client management, if once it's the judge says no, then Owens is like, well, we tried, and they can move on to something else. Because she is like a dog with a bone. She is not going to let it go. The detectives aren't going to risk their jobs for Miss Boone. Yeah, all this is Sarah's doing. So that is the first one. I wanted to start with the, I don't like to bury the lead. That was the most like, one of the bunch. The other ones are pretty routine, but let's just go through them quickly. Let me share this tab. And Sugar Bear. Oh, Sugar, be careful. Yes, you. Let me make sure I'm sharing my screen. Here we go. Let me take that one down. Hey, Angel Baby, Carolina, Traveling Teresa. Okay, let's go. So this has been amended. The motion for a declaration of indigency. Oh my God, indigency and payment of due process costs. So this is pretty much exactly the same. I'll just get to the amended part. Basically, this is where they've amended it. Request this court to declare her partially indigent for costs nunc pro tunc, which is now for then, to August 30th. So they're asking for it on the date of the hearing on the 19th, but they want it to go back to August 30th when James Owen had filed his notice of appearance and officially became her attorney. I don't know why I air quoted. He did officially become her attorney. And so that is what they changed there. I am going to be interested in if Judge Kranick has something to say about Owens going before the media saying he's not pro se and then saying in the courtroom that he was pro se, because he also had Sarah sign that affidavit saying that he was working for no payment from her or from anyone else and that she was indigent. Yeah, we'll see. And I think also there was one more thing I wanted to show you guys in there. Oh, yeah. They'll be severely prejudiced. Uh-oh. No. No, sir. Oh, my goodness. Sir. Come this way. Okay. Do you want to say hi? Okay. No, it's not in this one. There was one where it's he just hit my phone. Okay, I think now I'm back connected to the sound. Okay. Hold on. Oh my goodness. Oh. This is why the day streams are quieter. We're gonna go to another. We're gonna go to the forensic psychologist. This amended motion. Let me share this tab. So again, the significant change here is he wants it backdated, basically. And as I said in the other video, so she's seen her now a total of 5 times. The 5th time was right after the September 3rd hearing. So I'm curious how out of that amount of time she decided Sarah was eligible for the battered wife syndrome versus the 4 other times that she saw her and she had not. But because of this motion and him asking for it to be backdated, she'll get paid now for that. Here it is. Grant this motion, nunc pro tunc, to August 30th, the date he filed his notice of appearance herein. So that cost will be covered. I'm wondering, wait, let's go back. Did he ask for travel? He did. $200 per hour for work and travel time. I mean, I think they're taking advantage. Like, should you really be paid the same amount for traveling as when you're actually doing work? Like, you're getting paid $200 an hour to sit on a plane? Because he said Julie Harper was up by him. Those were his words. So, and he said his drive was like 6 hours. And at one point he mentioned he flew in. So to me, I don't know. What are y'all's thoughts? It's all on the taxpayer dime. That's the part that's annoying. Okay. So this, well, let me get through it. Oh my God, I have to stop. Stem. Uh-oh. Be careful. You're all done? Okay. Thank you. Yeah. Up. No, not up. Uh-oh. The boss. Can you guys see this tab? This person, if this is the right person, because he's in Pensacola, Florida, was like found with odd body parts in a storage container. I'm going to show you guys in a second. First of all, yeah, it's the right guy. So comes now the defendant by and through the undersigned attorney and moves this honorable court for the appointment of a due process provider to aid in the preparation of the defense. So they have to say due process provider, right? Because that's all that she's eligible for now is like whatever due process she needs, the JAC has to pay for it. So that's like a key part in the event that if Judge Kranick denied it, then that could be like a technicality that gets an appeal granted. So that's why he's putting in that due process. Defendant is charged, blah, blah, blah. Undersigned counsel has agreed to accept this case pro bono and request the assistance of a crime scene reconstructionist. He has decided to do everything that is noisy right now. To assist in the defense. Defendant is financially unable to hire a due process provider, crime scene reconstructionist, death investigator to aid in the preparation of the defense and therefore requires the assistance of the court to ensure the protection of her right to due process. The defense requests the court appoint Dr. Michael Birkeland, a crime scene reconstructionist, death investigator for the defendant, and they want a cap of $10,000. The state said in court on the 3rd of September, there was no position. Again, he wants it then or now for then. It's filed in good faith and for no other reason. And then he didn't change this. They're flinging out motions so fast and they're not updated because this says request the court appoint Dr. Julie Harper to assist the defense as a forensic psychologist. But on this part, it says the undersigned requests Dr. Michael Birkeland at this hourly rate. So which is it? I think those don't bode well, especially when you're sending a bunch of communications. And here he does not have the note or the email from the JAC saying they take no position. So either he sent it and they do take a position, but I don't know why he wouldn't state that. But I'm thinking that maybe he didn't send it. But that is not the realty. Or realty. It sounds like I said, like housing stuff. All right, let's look at this. This is what this is. This is dated August 29th. Let me see if I can make it bigger. Let me make sure you guys can see it. Okay, where are you guys? Okay. Dr. Michael Birkeland, a forensic pathologist who has been critical of the investigation into the death of 22-year-old Sheena Morris at a Bradenton Beach hotel, has been accused of crudely preserving human brains, hearts, and lungs in soda cups and plastic food containers found inside a storage unit in Pensacola. Birkeland has not been charged with any crime. A man bought the contents of a storage unit at auction last week in Pensacola and made the gruesome discovery after being overpowered by a strange smell while sifting through furniture and boxes. So I'm guessing this man didn't pay his storage and the other person bought the contents at an auction. But why would you leave brain, hearts, and lungs in soda cups and not pay the bill? Anybody? And he hasn't, I guess it's not a crime to have these things, but whose are they? Investigators found formaldehyde, a chemical used to embalm and preserve bodies, leaking from a 32-ounce drink cup, not a drink cup, with a cracked lid that was holding a heart. Was it a 7-Eleven 32-ounce cup? I need more details. I need to visualize. The unit had been rented previously by Birkeland. How horrible it is for the families of these deceased to think that someone's loved one's organs are basically rotting away in a storage unit somewhere. It's horrible, Martin said. So, could there be another Birkeland with the same name also in Pensacola? Could be. Eric Stevenson said his client had broken no laws and that the organs and tissues Birkeland had stored were acquired over the course of his work and were intended for destruction at a later date. Why was it in the 32-ounce drinking cup? Every profession has a certain way it stores things. Okay, can you guys not play on the bed? Get down, Liberty. Every profession has a certain way it stores things related to that profession, Stevenson said. Ultimately, these were intended to go to the incinerator for destruction. It's no different than files in a lawyer's office that ultimately go to a shredder. Birkeland is one of 4 medical experts who examined Morris's death. Birkeland examined crime scene photos of Morris taken after she was found in the hotel room, New Year's Day, 2009. Birkeland later brought in the other medical experts to examine the case. Birkeland and 2 others all came to the same conclusion that the scene had been staged to make it appear that Morris had killed herself. In my opinion, this has no effect on the Sheena Morris case. Of course, his lawyer said, I don't think the issue in that case will be storage of body parts or tissue. The issue in that case is good or bad police practices. So probably leaning toward bad. Morris's mother, Kelly Osbourne, had mixed emotions Wednesday after she learned of the allegations. I have got to hope there's an explanation for this, but it doesn't sue the other families who these organs belong to. See, now this makes me glad to be an organ donor because it should be going to a living person. So that kind of creeped me out. I'm not going to lie. That was yuck. But I guess it's technically not illegal. The reason they need him is because the state they have their own crime scene investigator and reconstructionist. And so it sounds like, well, at least hopefully, that Owens or someone on his team has read what the state's witness has testified to and read the depositions and wants to counter that, right? Which is their right to refute what that person has said. Hopefully. Someone said to me, what was it? A pay for play like a pay for play expert. Is that a thing? Can you really pay them to be an expert, to say what you want them to say? What's the matter? Yes, sir. Are you trying to get that out? Do you need help? Okay. Here you go. I just think I don't know. What does that say about him that he's taken home? Not only taken home, but put them in storage cups, like drinking cups. Why didn't they go to the incinerator? He put them in something, like the cups in, I don't know, a milk crate, and then put it in the back of his Subaru wagon, and then drove it to this storage, paid for the storage until he didn't pay for the storage, and then left them there to be sold at auction? If they're sleazy, but they can get cross-examined. Okay, yes. Dr. Barry. Okay, experts know that they won't get hired if they don't have an opinion that is helpful for this side. I have integrity and won't change my opinion to get hired. Oh, perfect. Okay, that makes sense. So during the process, like the interview process, the selection process, they already have an opinion that they are hoping that you agree with. And so if you don't agree with that, they don't hire you, which I don't want to be a cynicist or a cynic. I guess they could naturally agree with it, right? Based on the evidence, they agree with the conclusion that you've come to and it's beneficial to their case. And so then you go and testify. But if they are interviewing with someone who's like, I don't see that, or that's a stretch, then they won't hire that person. That makes sense. I was on a jury. There was a medical case. There were so many experts. None of them agreed. Prosecution side, it was a civil, and the defense, the plaintiff and the defense just didn't, the witnesses, and it was very detailed. It was a medical malpractice suit. And so, yeah, even with that of what happened during the surgery, they had such different opinions. And the thing is, you'll never know conclusively, right? So you have to look at the burden is a preponderance of the evidence in civil. So it was so many notes. It took us, I think the trial was 2 weeks, but it probably took us 3 days to deliberate. It was rough. And I remember in the notes, they said that Hobson, so attorney number 7, had a witness. Now, presumably, if there was an interview process, well, it had to be an interview process, but presumably during the interview process, this doctor knew what they were looking for. But then after the doctor actually, interviewed with Sarah, met with Sarah, and gave the professional opinion, they decided to do away with that doctor because Sarah didn't like the direction that the doctor went. So we'll see. I'm also curious. Hopefully the prosecution will attack the fact that Dr. Harper met with Sarah 4 times, did not have the opinion of battered wife, and then the 5th time after Owens has come on, she is willing to testify that she believes that Sarah suffers from battered wife syndrome. And it was like over a period of 2 to 3 hours, where prior to that, she had met with her a total of 13 hours and didn't have that opinion. So we'll see. Okay, let's get to too many tabs open here. That's the crime scene investigator. Sorry, guys, I lost my place. And then this is the Dr. Brannon. So this is the guy, we looked at him on Court TV. I put a clip of it in the other video where he was oh my goodness, is it Teresa? No, something Thomas. The Thomas case where her husband was on the couch asleep and she shot him in the back of the head and she walked. So motion to appoint clinical psychologist comes now the defendant by and through the undersigned attorney and moves this honorable court for the appointment of a due process provider to aid in the preparation of the defense in the above styled cause as grounds would show. The defendant is charged with second-degree murder and has previously been found indigent. Undersigned counsel has agreed to accept. Defendant is financially unable to hire a due process provider, clinical psychologist, to aid in the preparation of the defense. And again, he's using the due process and effective assistance of counsel, which are trigger words for if there was an appellate review, right? Due process, you don't want to deny that, and you definitely don't want a client to have ineffective assistance. And in this one, it's interesting because he's saying he would basically be ineffective as a counsel, as a lawyer, if she doesn't get this. Normally, it's the defendant saying, oh, my counselor sucked or my lawyer sucked, but he's saying he won't be able to effectively assist her without this. So that's interesting. I feel like they are padding as much of that in there to help when she doesn't get acquitted, help with her appeal, like the writing of the appeal. The defense requests the court appoint Dr. Michael Brannon, a clinical psychologist, for the defendant. Dr. Brannon is requesting and has been paid in other court-appointed cases a rate of $200 per hour to perform his duties. So they're asking for a cap. He will also get paid the same for his work hour as his travel time, with an initial cap of $7,500, exclusive of necessary costs allowed by statute. So that means there will be above and beyond whatever the statute allows. So this $7,500 could go up depending on what other necessary costs that he incurs that are allowed by statute. An additional reasonable coverage for travel and travel related expenses capped at $2,500. Good Lord. So we're already at 10,000, and then that doesn't even include the other possible necessary costs. In court on September 3rd, state indicated that it took no position regarding defendant's requests. And then again, we've got this motion nunc pro tunc, in case you just joined, that is now for then in Latin. He wants them to pay now, going back to then, and the then he indicates is August 30th, the date he filed his notice of appearance, which is interesting that he's asking for now for then for this guy. So does that mean he's been working with her? I did not see him on the latest visitors list. I think I had it through maybe the 15th. So maybe he's come in after that. And he wasn't on the video visit list. So And again, whoever is cutting and pasting this is doing a sloppy job because they still have Julie Harper. So I'm going to guess that first motion had Julie Harper's. Oh, hang on, guys. Okay. Oh, mommy, pick me up. Stop ignoring me. I'm guessing the first one was. But somebody should do like Controlled Alt F, like find all the instances of the prior one, or R. You want to replace it wherever it says this. You know what I mean? Like, I don't like this. It just in here anyway. It's just me being particular. And then the state came in. This is the last one. Notice of supplemental discovery comes now the state of Florida by and through the undersigned assistant state attorney. Oh yeah. Do you know who the state attorney is? Maybe. Well, they asked the information is available to the defense. Yeah, and it states that the arrest affidavit by A. Zito is ready, pages 422 through 423. So that's one page. Can you say one? One. Okay, so copies of items listed will be provided under separate cover. Previous discovery provided included pages 1 through 421. Please verify receipt of all pages and notify our office of any missing pages or duplicate numbers of discovery. So those are what was filed. That's what we're going to expect to see. There was no new motion filed for the motion to strike. So, oh my God, this one. Hi. Okay. Sir, I thought you were sleeping. Is it because I'm talking to other people? You want me to talk to you instead? Okay, I'll do that. Come over here. There was no change in the motions. Oh my God. Defense filed the battered spouse. State came back and said BS. Defense filed an amended battered spouse and added those detectives, the 4 Leos, the law enforcement officers, added Brian Boone, and the state did not respond to that. So we should expect to see oral arguments on that tomorrow. Yeah. One of you guys pointed out too, like all the money wasted from the video I posted earlier of like having, so the JAC paid Billy Lane to copy all of that discovery onto hard drives, and now she's back with the paper copies. So I don't know. She was upset about her laptop. If you guys haven't seen that video, thank you, Jane. I definitely recommend seeing what I posted earlier. I'm excited too, Nico, for tomorrow. Like I said, I'll be on in the evening because I have other things to do. Hey, Nico. I didn't even see you in here earlier. Bye, Olive Oil. Thanks for hanging out. Yeah, so let me just look and see if there's any. I know there's some stuff. Oh, hello. Your sister, Christy. Welcome to the membership. Cookie became a YouTube member. Welcome, welcome. Tammy, welcome. And they couldn't ask for physical custody of evidence like DNA. This is ridiculous. Yeah, I don't know what is going on with them. Again, I think part of it is client management. If he doesn't ask for it, he'll never hear the end of it for Sarah. She's going to go round and round and round. We've seen her do it in all the instances. That was when she told the attorney, what do you consider above and beyond from the jail, right? Like she's going to argue you down. She does not understand, no. I'm convinced of it. She does not understand. Did you see the defense? No. To extend time? No, I did not cover that one already. Let me go look. Extend time? Really? And let me guess. It's going to cause him to be ineffective as a lawyer. He won't be able to effectively. Okay, hold on. Let me see. Order for. Oh, wait. I'm down in 21 because I was looking at Padilla files. What? Let me see. Where? Return of property, supplemental, provision. Oh, motion for enlargement, extension of time. Okay. Let's see. Hello. Am I sharing it with you guys, first of all? Nope, I'm not. So I'm wrestling. I'm going to actually take myself out. Okay, so comes now the defendant, Sarah Boone. By and through undersigned, blah, blah, blah. Moves this honorable court for an enlargement of time. I have not heard it phrased that way. To file defendant's witness list, digital exhibit list, physical exhibit list, and any objections to the state's exhibits. And for good cause shown, states as follows. So these are the physical state's exhibits because they've already submitted. Oh, wait, no, that was Sarah that submitted the objection to the digital evidence. So that I'm imagining they have to strike that from the record tomorrow too, what she submitted. Someone said it's already been, is it struck? Because Owens came in. I didn't realize that it was like futuristically. I shouldn't do that. But it hadn't come into the record yet. But someone was saying even when it came in, it should be, but we'll see tomorrow. Okay, so on August 5th, the court entered its scheduling order and notice of hearing, setting forth deadlines for filing of witness list, exhibit list, and any objections thereto. Undersigned counsel filed his notice of appearance with the court on August 30th. Dr. Julie Harper met with the defendant, Sarah Boone, on Thursday, September 5th at the Orange County Jail in Orlando, Florida. Based on that interview, as well as the other meeting she had with the defendant, Dr. Harper formed the opinion that the defendant met the criteria for the battered spouse syndrome defense under Florida law. So this is interesting. He doesn't cite that it was 4 times before, because on the record in court last time, he said they had previously met 6 times, and Judge Kranick repeated that. So he's not clarifying here that on September 5th, that was her 5th time meeting her. Hopefully the state catches that. So they're going to use the battered spouse syndrome defense under Florida law. On Friday, September 6th, Dr. Harper advised the undersigned counsel of her opinion regarding the defendant's battered spouse syndrome. As a result, the defendant filed on Friday, February 6th, her notice of intent to rely on the battered spouse defense. Subsequent to the filing of the notice of intent to rely on the battered spouse defense, the defense has diligently attempted to gather corroborating evidence and witnesses in support of said defense. You cannot gather evidence that does not exist, Mr. Owens. I don't know who is corroborating this. It can't be hearsay. They have to have seen it. I want to know who that was. Okay. So the defense investigation only began once the doctor formed her opinion, which that is BS, because you said you were of a notion to file it while it was on the 3rd. Well, I guess it's only 2 days. I won't quibble. So the 3rd is when he already knew he wanted to file it. She officially signed off on it on the 5th, and he was okay. So that's 2-3 days max if he wants to count the Friday where he filed it from the 3rd till the 6th. So it only began once the doctor formed her opinion. The alleged crime occurred on or about February 24th, 2020. The defense is having difficulty locating witnesses and gathering evidence to help establish and support the defense due to the passage of time or due to their non-existence. Tanika's 2 cents. The investigation is ongoing, and the defense anticipates additional witnesses and other evidence will be uncovered. The court has set the matter for trial on Monday, October 7th. The defense anticipates amending its reciprocal discovery obligations up to and throughout the 2-week trial. Now, how can they do that? Because then the state has to respond in that same time. If he says throughout the 2-week trial, if you give it 2 days before closing, how will the state have time to counter it if need be? Do you know what I mean? I mean, I guess they could arguably already have it, but what if they I don't like this. The above referenced court order sets forth a deadline of August 17th for defense to file any objections. And he actually changed it to August 23rd. And he said that he, being Judge Kranick, on the record on the 3rd. Defendant respectfully moves this honorable court to enter an order extending the deadlines for defense to file any objections to the state's exhibits, and for defendant to file witness and exhibit lists for the period of time up to and throughout the 2-week trial. And wait, did he sneak that in there? When did we officially get to a 2-week trial? I thought we were at 3 weeks. Did the judge take a week back? Remember, he extended it to a week for Sarah. I don't remember him saying it. I don't remember him saying it will be reduced back to. Did I miss that? You guys let me know. Let's crowdsource. I don't remember him saying that at all. Okay. Defendant, through undersigned counsel, moves this honorable court for an enlargement of time within which to file any objections to the state's exhibits, the defendant to file witness and exhibit list. So he's not asking for an extension outright then. I think he is skirting around that request. And instead of asking again, because the judge already said no last time, he doesn't want to come again asking him to delay the trial, but he's asking him to extend the time within the existing timeline to do more work. Because normally, unless it's for a rebuttal, like, you're not still giving evidence, like new evidence to the opposing side. You know what I mean? Like, I mean, could backfire on him because the state is definitely going to have more resources than he has. You know, I mean, he has a nice little scrappy group that he put together, but I would say the state is better positioned to respond quickly. They have the resources if they need to research something, whereas I don't think the defense, because he can't have it unilaterally, right? Like, what's good for the goose is good for the gander, is what my mama told me. So if he's asking for it for the defense, then the state is automatically going to get the same extension. And so if he's coming in with like, oh, I found, I don't know, a videotape, a secret recording, the state then has the right to authenticate that recording. So like I said, if he gives it like 2 days before closing, when he's in his case in chief, the state has the right to be able to examine it for its validity. Okay, the judge did not amend the trial length, but he extended it because he knew that Sarah being pro se was going to be a nightmare. I think Owens just presumes it'll be shorter than 3 weeks. Okay. See, I was thinking it would be shorter than 2 weeks. I mean, shorter than 3 weeks too. And that's why I thought, well, maybe the judge will give him a 1-week extension, because if you would still end the trial at the time that you thought you were going to end it, instead of just automatically starting in October 7th, that Monday started the following Monday and you would still end it. That's what I was thinking. But it didn't, like, that didn't come to fruition. But now it's sort of like, is he Jedi mind tricking Judge Kranig into a 2-week trial? Yes, Leslie, she sure did. She refused it, these proposed defenses, because she didn't want to admit guilt, right? If this is the defense, you have to admit that you intentionally did it. Yet she swore on her son's life that she did not intentionally do it. I bet that's also part of the interrogation they want to get removed. That is not going to sit well with the moms on the jury. I know if I heard someone had said that and then flip-flopped on it, that wouldn't sit well. I know some people don't take it seriously. Like, I remember, well, I won't get into my personal life, but everybody doesn't take that seriously. But the fact that you said it, why? Birkeland was charged with that. He was charged with it. Is it the same Birkeland, Carol? I just thought that was weird. What was the, like, tampering with body parts, or I don't know, something gross acts with the corpse? Like, it just seems, but apparently he's still working again, unless there's 2 of him. She accidentally killed him on purpose, basically, right? And that good day, that's the thing where I'm curious as to what Dr. What was his name? Brannon is going to say, because he kind of talks about how things get distorted when you've been in that abusive situation, and imminent, like, to you or I, or someone who is, clearly grounded in reality and not going through that type of trauma, would not see it that way. Which, I mean, I'm open to that, because Sarah sees the world a completely different way from how I see the world, even as a person who experienced past trauma. Sarah's on a whole other level, and her level of entitlement is off the charts to me. Like, mine was a self-esteem issue that I had to work through therapy. Sarah's not, well, at least not outwardly. Maybe that's like the bully who pretends to be tough but is really like soft and mushy, because she's hell on wheels to everybody. Oh, what did Lisa Crow know? Hi, Anna Fernandez. I gotta find Lisa Crow's mark now. The whole trial will be the shit show of the year. Owens will probably be on 9 interviews. Oh my God. After hearing tomorrow, he can't talk enough. I know. And you notice in all the interviews, he gets cut off. Like, the first one I put in the clip where I was like, is he talking out of both sides of his mouth? Like, she was like, okay, I have 10 seconds. Like, and then real quick, yes or no, because he likes to hear himself talk and he's long-winded. I'm sure it's easy for he and Sarah to go through hours like the rest of us go through minutes. It's like, oh my God. Same Brooklyn. Okay. Oh, based on his CV. I didn't look for his CV. I'm going to have to go back. I was trying to figure out, I was actually trying to look for licensing, and I'll do that later, but like, how are they licensed? And did this person get a strike on the license for that? I mean, I would assume that violates some ethical rule to be putting body parts in slushy cups, Slurpee cups. I could be wrong. I don't think Sarah looked at all the exhibits because she seems the type to focus on one thing and harp on it. I agree. Summa cum laude, BSN. Congratulations. That's kind of badass. I agree. Look how much time she spent writing letters about the boxes. Look how much time she spent focusing on why wasn't she getting the internet. Like, she could have been, she already had the digital copies in her possession when she continued to write about the ability to have the paper copies. Someone mentioned she might not be computer literate. I mean, I guess there's like degrees of literacy on the computer. I feel like opening up the files is pretty straightforward. You know what I mean? Yeah. And imagine if she had the internet, she'd never be looking at any of that discovery. But yeah, it's she is, what is it, like one thing at a time? She becomes laser focused on it, and the rest of it is just kind of out in the abyss somewhere. She's not really, which is interesting because she made that point in her interview of like, George can only focus on one thing, but I can focus on what I have to do next and previously. But like, previously, that means you've already done it, so why are you focusing on it? You know, like she made a lot of odd statements in that interrogation. She was like, I have to pick up Lucas. I have to do these things. I have things to do the next day. Meanwhile, what time did you wake up today, ma'am? Yeah, it's crazy. I don't get what her issue is with that phone. It has to be done by a specific person in a specific room. Is that what it's called? Faraday? Or you put question mark? I think that's what he said. I couldn't make it out. But yeah, so that it doesn't receive a signal. The only way to turn it on is in that specific room. And like when Sarah was like, oh, I would like to have it so that I can extract it. Ma'am, no. And I would think you would be able to see the photos in a file at this point, right? Like, what is, but listen, Owens is asking, and we'll see. If the MH expert first met Sarah in August 22, what is the mental health? Yes, she met her the first time. That's right. Under Mauricio Padilla. She met her 4 times. So she met her in August of 2020. Then she didn't meet her again until a year later in August of 21. And then it was like the end of 21. No. There was 2 more in 2022, early in 2022, like February or March, and then a later one in the middle of the year. And then whenever Padilla was gone, she did not come back to see Sarah. It was because she was pro se. The 3 weeks. Yeah, it definitely was, because before that, when Cashman had and the other guy, Cacciatore, they had estimated like about a week and a half for the trial, and then 3 days for jury, or 2 days, whatever it was. It ended up being like 10 days total. And then once Sarah became pro se, Judge Kranick, in all his wisdom, added that extra week. I think they would have been 4 or 5 weeks, honestly, because he is a real lawyer. He used to be like the head poobah of the grand poobahs of defense So like how you have the assistant state or the state attorney and assistant state attorney, he was like the public defender, and then he had like deputy public defenders underneath him. And his childhood friend, who's now helping on the case, Tony Henderson, ran against him in the same race to be the public defender. Oh shoot, I forget the Mac does that. Can you guys see those balloons? I forget the hand signal. It's so weird. But he ran against him, he lost, and then he was appointed like one of the deputy public defenders. Hey, Liberty, stop growling at Justice. Stop that. And then I don't know exactly how he knows Kevin Beck. Is it Kevin? What did I say? Kevin James? Whatever. I think it's Kevin Beck. But that guy lives in New Mexico. So he'll be attending tomorrow via Zoom. JAC's attending tomorrow via Zoom. But yeah, so they all have something kind of sorted in their past, because Henderson got investigated for Pedialyte activities with children. You know what I mean? YouTube friendly. And he did not go to trial for it, or he was never charged with it because it was past the statute of limitations. And there was something else I can't remember off the top of my head that he did while also working under Owens, and they were both kind of tainted by that. And then Owens got voted out of office. So it is, but I also feel like defense attorneys are more willing to bend rules. Just like you have to have that kind of I don't want to say bend rules, because I'm not trying to imply that in and of itself is unethical, but like how you understand something really well, and you understand like what that fine line is that you can ride. I feel like defense attorneys ride that line for a living. So I'm not saying diddling with children is right, or that definitely is wrong. There's no fine line in that. The line is clear, and he crossed it allegedly. Okay. She was claustrophobic the day after she stuck. Oh yeah, she said that in the interrogation. She's all worried about where she's going. No benzos in the county jail, but they are given Seroquel, trazodone, and other strong meds. Those take you down, right? I remember doing a commercial for Seroquel, and my character had to be bipolar. But that's all I know. I don't know about trazodone. Although I think one of those wasn't Stevens. Stearns taking that in the Maddie Soto case, or he was giving it. I don't remember. Steve Jackson, Seroquel at 6 p.m. would be rough. I'd be asleep by 7. I know she's getting heart medication, because if you looked at my what I posted earlier today, she was getting, or high blood pressure. I'm sorry. I don't know if that's specifically her. She was getting high blood pressure meds. And I know in the notes at some point, I think it was 22, she had some kind of surgery. That's when she started needing the double pillow. Or it might have been 21. Yes. Exactly, HRH mom. Exactly. And I can't believe they put Brian. That's what I'm saying, though. I don't know what evidence they're looking at. They clearly have not looked at the body cam footage of Brian or the audio of Brian in the car. He's said that Sarah has hit him, scratched him. What did he call them? Claws, scratched at his neck. And he felt like if George had better restraint, he wouldn't be baited by Brian or by Sarah, because Brian noted, I have great restraint. But also, it was kind of sad because Brian did like this nervous laughter, either out of embarrassment of being in a abusive relationship or not wanting to admit that it was an abusive relationship. I wonder if she's on anxiety medication, like an SSRI or something for sleep. Yes, I'm on one. I'm on Zoloft. They extended time to 9/26 for discovery, for the response to the discovery in the witness list. Which one did they extend? I love how you guys are on top of all this. Yes, reworked the English language for it. They sure did. Yes, I think he is too. They're going to have to pound sand. Wants to be able to turn over and discover. That just seems crazy to me. An enlargement of time. That is, whew. I don't know why he didn't say expansion of time. The enlargement is like, I don't know, maybe it's my blue humor, but I'm like, say what now? Asking judge to make the days go by slower. Wait. Yeah, that is crazy. Oh, understood. It is. It is still up over there. Um, I'll bring the soda. It'll be a boom party. Yes. Oh my God. He's asleep now. Oh my God. Court docket as a bitch. So yeah, that is it. I just wanted to come on because I saw all of these emotions dropping and I was like, oh my God, this is crazy. And they've submitted witness lists. We only get the front page, so we don't know who the witnesses are. JAC, Henderson, and Beck will be attending via Zoom. Owens will be there in person. I just think he's going to be all hopped up and running around the courtroom, but we will see. So, yeah. I don't see why the judge would not grant for like the payment for Julie Harper, but I'm curious as to why. I think there was one of them, I'm looking now, where he included the JAC, but the other ones he didn't. But the JAC is on notice to be there tomorrow. But remember when Judge Cranick had said, we will expedite this? Oh, thank you. Who sent that? Thank you, Tammy. I appreciate you. Gets 16 continuances due to her inability to work with anyone. And now she wants to say the passage of time causes an unfair disadvantage to finding their witnesses. I know. Balls of a burglar. Balls of a burglar. And James Owens is co-signing it. It is very, very interesting to me. But we'll see. We'll see how I don't think Judge is gonna entertain any of this foolishness. What was I saying right before I saw that? Oh my God, it'll come to me later. But it should be very interesting tomorrow. I expect that it'll be fiery. I expect that Cacciatore and Jay will be there. I hope it is, well, I don't care who it is from the JAC, but I did like, what was his name that was there last time? I can't remember his name. But yeah, we'll see. And do they have enough time? Like the death investigator crime scene recreation, how much time is that going to take? Yeah, so I think that's why they're asking for the enlargement, but I think that the state is going to object. I can't see them not objecting. Like that'd be a whole other like second team, back in the office. Well, they said the office was around the corner, but a whole second team pulling up data. And I just think of it like fact checkers at a debate, and they're in the back trying to, you would have to have somebody fully, like full time, addressing these things as they're coming in during trial, because the trial counsel is focused on what's happening before them, right? And like finding rebuttal witnesses or identifying if that was if someone committed perjury and they want to impeach them. Like they're not going to have time then at night to go and find rebuttals for whatever discovery or an expert to offer a different opinion. Do you know what I mean? But like I said, if anybody can do it of the two, it would be the state, because they're going to have more resources. So if then the state starts saying, well, we're going to add discovery, who's going to be doing that for Team Sarah? It's just a little weird. A little weird. Okay. I would have loved to tell. Yeah. I know whoever the guard was that got to tell her was happy to tell her that, and you could tell Sarah was mad because she was like, she can't do that. There's a court order. I'm gonna tell the judge. But yeah, all right. I'm not gonna hold you guys. Like I said, I just wanted to do a little trial prep so we all know what to expect for tomorrow. It should be feisty, and then I'll be back around this time tomorrow night, and we can. I want to hear your thoughts, and I'm going to give you my thoughts on how it went. So you guys get your popcorn ready. It is definitely going to be interesting. All right, everybody. I think that is it. Unless there's any more questions. Have a good night, Thee. Good night. I want to see how Sarah comes dressed for trial. Oh my God. I think she's gonna wear pants now. I think what's his face is gonna talk her into that. I just don't see yeah, I think he's gonna talk her into that. Because oh my god. How do I want to say this? I want to be appropriate. I don't think her mannerisms are going to go well with the skirt. And the jury's not going to see this skirt. So I think he'll be able to talk her into the pants. Do you know what I mean? Just so she can sit comfortably and feel natural. So that's not one more thing that she's like under the table tugging on her skirt or whatever. I think they'll just, yeah. Oh, wait, one more. Thank you, Melody, Kate. I appreciate you. Oh my God. I know it's rough for some people with the baby and the dogs. I do give the warning. They do live with me. They are my heart and soul. So they don't bother me, but I know sometimes the dogs make other people dogs bark, and some people just don't like the sound of babies. I get it. So I appreciate all of you guys who rock with me. And I will continue to give the warning for those who rock with me, but don't want to rock with my little fur babies and my real baby. Have a great night, everybody. I appreciate you. And I'm trying to find my outro. And I'll talk to you later. Toodles. Bye.